All right, we are live for an. We've done it. We've had this happen before, where we've had a Friday weekend because this. I'm here with Elisa Tab and Greg Siskin. Um, the one theme since the first Trump administration is the Friday afternoon mega news drop of something super important that drops on a Friday. Actually, that was this morning, so it wasn't quite Friday afternoon, but it has the same effect because we'll be thinking about it all through the long weekend. But they did that today with something that potentially has monumental effects or not, depending on which people you talk to. But I think it will. But anyway, this is a new policy memo that was brought out today on adjustment of status, and it essentially tries to turn adjustment of status from something that's relatively predictable and routinely approved process to one that it seemingly would be, I don't know if rarely approved, but certainly way less approved than it has been. So, um, Elisa, you worked on a client advisory today that kind of went through and you went through it in some detail to be able to tell our clients what's happening. So I'm going to let you take the lead in explaining what happened.
Okay. Well, I think it was around 9 o'clock this morning, and I was just checking my email like you do, and this thing came across my email, and the headline on the email, for those of you maybe who haven't seen it, I'm going to read to you what the headline of the email was. USCIS will grant adjustment of status only in extraordinary circumstances. So I see this email subject header and I'm like, what could this mean? And I read the first paragraph of it, which basically says that USCIS is going to prefer that individuals seek green cards through the consular processing function, where they have to leave the United States and go for an interview with a US consular officer before they can get a green card, rather than adjusting status in the United States like so many people do. So when I first read this and like read it carefully, at first blush, it makes it sound like USCIS is no longer going to entertain adjustment of status applications. And I literally was like, I couldn't even speak. I was just like, what happened? Like, this is crazy. And then as we started to kind of dig more into it and read USCIS's policy memorandum, what they seem to be doing is saying that they really don't want people to adjust status, that they want people to have to leave the US before seeking green cards, that somehow adjusting status is now viewed by the agency as being untoward, or some end around to not have to go through a usual process. They refer to it as extraordinary, as unusual. I've seen news headlines talking about adjustment as a loophole. It's none of those things. The policy memo that came out, we could talk about this more in depth, is a lot of gaslighting about how adjustment was never really intended to be a real process. It really was only supposed to be used in extraordinary circumstances and for special people. Everybody's really supposed to seek a green card before they come to the US. And for people who come to the United States on visas, like visitor visas, H-1Bs, O's, P's, F's, J's, those people shouldn't be using their non-immigrant status as an entry point to seeking a green card. And I hate to tell them, but that's exactly how the law is written. You come here on a non-immigrant visa, you come here and you gain a non-immigrant status, and then you adjust to become a lawful permanent resident. That's how the process works.
Right.
This memo says, no, it's not supposed to be that way.
Yeah. So, like, if you come on an H-1B, which is dual intent, you're basically, they're encouraging you. There are even categories. Lisa, you and I do a lot of doctors. They create this whole pathway that is specifically designed to lure doctors to the United States on a non-immigrant visa, give them great training, and convince them how awesome it would be if they stayed in adjusted status. In fact, if you stay in if you stay and go work in an underserved area, we will let you adjust status and give you give you after 5 years permanent status. Congress has basically gone from, I think at the very beginning when adjustment of status was introduced, and 245A was written, it was, it was still consular processing dominant, and it was the idea, I think, at the very earliest stages this was something that we might be able to use as a reward to people who were doing, who were complying with the rules and doing everything correctly. That why should they have to spend all the money to go out of the country? And it happened to do a favor for the U.S., which it was much less expensive to process them domestically than to have to deal with them at a consulate abroad. So we have had that, that's the way it looked when, I guess it was, when adjustment started 40, I don't even know how many years ago it started, but it was probably in the 60s.
They cite case law from the 60s and 70s about adjustment in order to justify this policy.
But boy, did Congress change this over the years to the point where it is the dominant way that it is done. And it is no longer, it's in some years, it's the majority of applicants are coming in through adjustment of status versus consular processing.
And certainly for employment-based applicants, like for, you mentioned doctors, it's very difficult to consular process a physician national interest waiver green card because the person has to come here and work in an underserved area for 5 years before they're eligible. They're gonna be here. They're not gonna be processing that from abroad. Yeah. Maybe they're part of the extraordinary circumstances that the government's talking about, but there are so many ways that Congress has enhanced the ability of people to adjust. For employment-based cases, they even forgive up to 180 days of status violation, unauthorized work, that sort of thing. For people who are from backlogged countries who are here in H-1Bs, the AC-21 law gives them the ability to stay and extend their H-1B for as long as needed so that they can ultimately adjust. And it gives people who have pending adjustment applications the ability to port those applications to a new employer if that application is pending for more than 6 months. So Congress has, and I'm sure there are other examples, but Congress has created the regime we are currently living under, where they understood that people are going to seek green cards from here. And in fact, AC 21, the actual name of that law is American Competitiveness in the 21st Century Act. Congress understood that for America to compete on the world stage in the 21st century, we needed to make certain immigration processes more friendly to the immigrants who come here. And they created this whole regime that we currently are under for exactly that purpose. And today the Immigration Service is like, nah, that doesn't really exist. Sorry, this isn't really what you think it is. All of that was meant as an exception. And that's just not the way things have been.
Yeah. So we had AC 21, which basically created adjustment portability and extending H-1Bs longer while you have an adjustment pending. Obviously, the plan, the idea with Congress was they wanted the adjustment program to be more popular and work better and allow people to use it more effectively. We had 245I and 245K at various points. Well, 245K is still there, but 245I was another one where they were in that one. This whole idea of discretion, what has been the subject of discretion over the decades is essentially whether to forgive a violation of status that had happened if somebody, had a status violation of some sort or another before they were filing, when they were about to file the adjustment of status. Right now, it's very difficult to file under those circumstances because of this discretion factor. Congress during various has even broadened that. So 245I, when it existed, basically let people pay a fine. And in that case, even that discretion was taken away from USCIS if they would be willing to pay the fine. And in 245K, it said basically we'll accept minor, relatively short-term violations of your status for 180 days and let you file in employment-based cases. I think only 245K is available. But in those cases, that's where Congress was taking away just that discretion, but it was already pretty limited in the first place and when it could be used. This whole idea that it was ever intended to be sort of used in extraordinary circumstances as opposed to a routine filing. That is not factual at all. And when you use the term gaslighting before to describe it, you were right on the nose for that. So that's a those are obviously going to be important legal arguments. And I don't know when you want to talk about lawsuits, but that's something that we do want to talk about today.
Yeah, why don't let's talk about, I think what most people are interested just right off the bat is what happens now. And so we can talk about that, and then we can talk about possible litigation in a bit. Because I think one of the things, if you read the memo, right, there was an email and then there was a memo. The email is like lots of vitriol. The memo is too, but the memo actually gives us some tidbits. There are 2 paragraphs toward the end of the memo that USCIS really lays out what they're going to do here. And they say that USCIS officers, when they're considering adjustment applications, are going to consider the totality of the circumstances to determine whether someone is eligible. And that's going to include looking at positive and negative factors. And I haven't thought about one of these, but including, they just say family ties. They don't say to where. Immigration status and history, the applicant's moral character, and any other relevant factor that bears on determining whether the person warrants a favorable exercise of discretion. And then they remind officers, like, if you're going to deny an adjustment on this basis, if you're going to say that USCIS is exercising discretion to deny, you have to explain exactly what positive and negative factors you examine in making that decision. So, I think when we talk about these factors, and that's all they say, by the way, USCIS does not provide a list of potentially acceptable documents. They don't give examples. There's no Q&A. Like, back in the olden days when USCIS would issue a policy memo like this, they'd give you like scenario examples to say, like, if this, what if the circumstances are like this? This is how we would decide it. But they don't give any of that here. So when they say family ties, like the first thing I thought of was, well, family ties to where? And is that a positive or negative factor? Because if you came to the United States on a J-1 visa 4 years ago and you disclosed all your family in the United States and you have siblings and an aunt and uncle who are US citizens or, cousins and stuff, and you disclosed all of that when you came, and you now have gone through your program, you are, maybe at a point where you're ready to file an adjustment of status, and USCIS looks at the fact that you have US citizen family in the United States. Is that a positive because they're like, we want to keep the family together? Or is that a negative because they're like, oh, when you came here on your J all those years ago, you must have known you were going to stay because look at all this family you have here. And now they feel like maybe you did something untoward. I don't know, right? I don't want to scare anybody about that, but that's something. They just say family ties. They don't say family ties to the US. They don't say whether they want to see that you have strong family ties at home so that they can feel comfortable that you came here temporarily for real. So I think we need to, like, there's a lot of things that are still not spelled out with this memo. But I think as people are going to file adjustment of status applications, it's worth a discussion with your attorney about whether there's additional evidence that you should be submitting, letters from people in your community that are like character references, like we're currently doing for some naturalization cases. Proof, obviously when we file an adjustment, we always include proof that you've maintained, a continuous immigration status in the US. But, anything else, for my doctor clients, that may be us just including a paragraph in your case to say you're a physician, what your practice is, where you work, and that, USCIS should exercise favorable discretion so that your patients aren't left without health care. So there are lots of different ways that this can come up, but I definitely think that these cases are going to become more important. You're also going to want to share anything with your lawyer about past status violations, past criminal interactions, whether in the US or anywhere else in the world, anything at all that you're worried about that might be a problem. Now, your lawyer may say, not a problem, right? And there may be lots of things that you get nervous about that we don't, but I think it's better for you to be fully truthful with your attorney and tell them all the information so that they can help you make that determination rather than you trying to make that determination by yourself.
And one of the things, Elisa, and I know we've been talking about it at our firm a lot, is the ability for USCIS and the other agencies to all see your whole history and see what was said to other agencies in ways that never were possible before. So you need to assume that things that you put on a visa application, 10, 15 years ago are visible to a USCIS examiner today that may be adjudicating something that's completely unrelated to that old application. And so you really do need to give your, first of all, save your information and obviously have it available and know what you've said. But those are the traps, are when you are, when you're not telling your lawyer about things and it becomes a surprise when it's brought up, and the lawyer didn't know anything about it, and you might have forgotten about it, honestly. But if you know about it, you should certainly make the assumption. It's better to tell them, even if you don't think it's relevant, and let them make the decision. With respect to this new worthiness standard that we're seeing in here, I mean, we sort of have been seeing this come up already in other areas in the administration, naturalizations for one. But basically, when we're talking about what makes you worthy, there are a few factors. One is if you're doing it based on even if you're not doing it based on employment and you're doing it based on family, your professional and your economic contributions can certainly be something that you can highlight if you have specialized expertise, if the work you're doing has a particularly important economic impact. Elisa mentioned doctors who are doing, serving underserved areas. Future potential, if you're a startup company and you have some, doing some really innovative stuff, all that would be highlighted. The family and community ties. Now, Elisa was talking about the fact that it kind of cuts both ways, where they may say it's like, if you really were intending to leave, why did you have all these family here? But you can highlight things like your U.S. citizen family ties, the impact of separation and what that would mean for your family, how well you've integrated into your community. So if you've been involved in professional organizations or congregations or local community groups, if you own a home and you have and you're rooted in your community, those count for good moral character. It's not just enough to have no criminal record, but to show that you've been involved with like volunteerism and you're, and doing things in the community. Those are the kind of things that you can and should address proactively in the applications. And don't be surprised if your lawyers now say, yeah, this is going to take a little bit longer to put these applications together because we have to add all these things to them. So give your lawyers a little space now that these applications are going to be somewhat tougher. But you should be looking at those, and you should also be thinking about the negative factors and how you're going to address them. So if you've had if you've had a layoff or you've had some, history of underemployment, if you've had some unauthorized employment, if you've ever, if you're from countries that are high risk countries, you need to look sort of at all the things that USCIS is being told are negative factors and work with your lawyer in how to address those particular factors, because they're going to be important. And, maybe this will all go away with litigation, but I think the theme of this administration is always going to be look for reasons to deny. So you can only be helped when you sort of emphasize some of these factors anyway. Even if this goes away, I think some examiners are still going to be applying it in general in the way that they view an application.
Yeah. I mean, so I think the general advice holds true, and keep in mind that we lawyers, like, we found out about this about 9 a.m. Central time, sometime around there this morning. And it's rolled out, like, people kind of discovered it at all different times of the day. So if you're already working with an immigration attorney and they haven't reached out to you directly to say, hey, let's have a conversation about this, it's because we're all still figuring out exactly what this means. I can't tell you, I'm on like 10 different listservs, And the conversations and the messages are just flying around today with people really very nervous about this, very concerned for their clients, trying to figure out actually how to apply this. Folks who have maybe marriage-based green card applications pending, who have, interviews scheduled for the coming week, worrying about like, okay, well, what's going to happen at that interview? And, so I think follow your lawyer's guidance, but understand that they also are trying to formulate that guidance right now. We sent out a written alert to our clients today, or to a lot of our employer clients today. That alert actually says, we're probably going to come up with an evidence list that we're going to supplement our adjustment intake with, but we haven't written that yet.
Lisa, have they said does this apply to applications currently pending or only future?
It doesn't say. It says it's immediately effective. So I am assuming that this is applying to adjustment cases that are pending. Now I've had some approved as recently as yesterday. So clearly, this wasn't implemented before today. I don't know for USCIS officers, they are usually given guidance by the agency. And so we don't know. And we kind of can suspect that officers haven't been trained on this yet because the policy memo was dated yesterday and it came out today publicly. I would venture to guess that frontline officers who are making these decisions haven't been told exactly how to apply it.
I think it was done almost secretly.
Yeah.
We were speculating about this offline.
Mm-hmm.
My theory is that the people that were pushing for this internally, some of the political policy folks, did not want this to go through legal and did not want this to go through rulemaking and regulations because they knew that would be a really hard fight for them to win. So they pushed this out through a memo instead of through rulemaking. Because it's a lot easier to write a memo. Now, the problem with writing a memo, and we learned this in the first Trump administration, is memos are really vulnerable to litigation. You have a lot more protection to protect a policy if it's a legislative rule and you push it out through rulemaking. They didn't do that here, and I think they didn't do that here because they were trying to avoid the lawyers. Internally. So,
well, and I will say, for people who have pending adjustments, so, that kind of comes back to, well, do officers even know what to do with this? Have they been given instructions? My assumption is no. I don't think they've been given instructions. However, right now for people who have adjustments pending, I think one of two things is going to happen. I think you're either just going to get an approval like you otherwise would have gotten, right? Like no big deal. Or, maybe there's a request for evidence that issues that says, hey, your application didn't include, you didn't address any of the discretionary factors. We need to see more information about your good moral character or, whatever it is. So I think we may see increased RFEs on adjustments that are already pending before this memo was implemented, asking us to address the discretionary factors. That would not surprise me. Could there be an increase in adjustment denials in the wake of this memo? Yes, that is certainly possible because some officers may take a harder line than others and may say, well, look, you're supposed to consular process and you haven't shown us why we should do something extraordinary here for you. So I think that, as we all know, USCIS, even when they come out with the policy memo and even when they instruct their officers, those officers do not apply those policies consistently or in lockstep. Cases that are similar to each other are going to come out differently. They're going to be handled in different time frames with no way to really tell you with any specificity what you can expect. Nobody can tell you that. But on the likelihood of things that could happen, I think we may be looking at a big influx of RFEs and pending adjustments about this. And actually, Greg, we, just before we went live, we were talking about why USCIS even did this memo in the first place. And I'm a little perplexed about this because back in November, I think it was in November, USCIS issued a whole new policy memo creating all of these new discretionary factors anytime they are faced with a petitioner application that allows them to make the decision within their discretion. And that goes for non-immigrant, extensions of stay, changes of employer, amendments, changes of status, all kinds of things are discretionary. And USCIS, I mean, I was just looking at it before in Chapter 8 of their policy memo. I mean, it goes on and on and on about discretionary factors and what they're going to consider in these cases. Why did they need this memo?
Well, I have a response to that, and that is there's that adjustments are different, and there's actual case law in the adjustment space. There's a case called Matter of Array or Array, ARAI, and it's from 1970, and it basically says that absent serious negatives, adjustments should ordinarily be granted. And this memo today is flipping the default to denial without admitting it, they're changing anything. But that's basically what they're doing today. But adjustments were, in terms of discretion, there's discretion, and then there's in some cases where it's mostly about discretion. That might be, for example, like an O1 application. It's very much in the eye of the beholder. And then there's discretion where it's generally left for very specific circumstances, and especially over decades where we've had, since the 1960s, we've had adjustment of status. Basically, the way it's worked since in the last 60 years that we've had adjustment of status is, there's basically under 245A, you have to have a legal entry or admission to the U.S. And there's very specific things. It does say that you have to that there is discretion, but the discretion has generally been if somebody has had status violations or is out of status at the point when they're filing the adjustment application. Mm-hmm. That is where the discretion has typically been exercised. In fact, I can't think of another instance where somebody was admissible. They were in status where discretion ever meant anything other than whether the person had status violations previously or they were out of status when they wanted to file. And in fact, Congress, even from time to time, told USCIS or INS that they were to look the other way on that discretionary analysis because they were putting a policy in place. So 245I, for example, is a section of the Immigration Act. Used to be, most people don't know about 245I because it's been so many years ago since it was in effect. I think 2001 was the last time it was in place. But basically, you could pay a fine and it lets you file an adjustment application and excuse the status violation. 245K we've had in the books for a long time, and that came later after adjustments were allowed to say, you know what, USCIS examiners, you have the discretion to deny if there have been status violations. We're going to take some of that discretion away and say that if there's an employment-based adjustment application, you've had a violation for less than 6 months, we're going to allow that to go as well. So all Congress has been doing over the years is expanding the adjustment program and taking discretion away essentially from officers and what they can do. So to pretend that they've always had this broad discretionary power is the gaslighting that you were talking about in your great quotes that you've had on social media earlier today. So I would say that's that matter when litigation happens, that case is definitely going to be an important part of the arguments. But also it's all about what Congress intended, and it's not about what USCIS decides that they want to do for themselves. So we have a great Supreme Court decision in Loper Bright that came out last year, and Loper Bright basically says that the agencies don't get a lot of leeway in terms of making arguments. So if USCIS wants to say we're going to completely change the way we're going to decide what's discretion, and it's contrary to what Congress has said over the years, Congress wins, not USCIS, even if they feel like they have rational reasons for it. We have dual intent that is embedded in legislation for H-1Bs and L-1 workers, where they specifically are saying that is not a negative factor, even though in this memo today they say that coming in on a non-immigrant visa is a negative when you're trying to apply for adjustment of status and showing that you weren't intending to use it. And so counting failure to depart as a negative factor penalizes people for doing exactly what the statute lets them do. That's circular and that's arbitrary under the Administrative Procedures Act. There are tons of legal arguments here, but the biggest one is the failure to go through rulemaking for something of this magnitude, which is something that that's why we have the Administrative Procedures Act.
Right. And that's why they're trying to gaslight by saying this has always been the rule, because they know that the memo is vulnerable to litigation. And I think, it's hard to say, I don't want to say outright, oh, this memo has no chance of surviving a legal challenge, because that's not true, right? We all know that there's no guarantee on anything that has to do with immigration or lawsuits. But I think this memo is really vulnerable to a legal challenge. Mm-hmm. And I think there will be more than one, to be quite honest. This is so wide ranging. There are so many people who are subject to this policy, right? The I-485 adjustment of status application is used universally anytime somebody seeks a green card from inside the United States, regardless of category. So there are a lot of people who have a vested interest in seeing this policy overturned and essentially forcing USCIS, if they want to change the way that they're adjudicating these things, they should have to do it the right way that they think that immigrants should do it the right way. They should do it the right way and actually make a rule or talk to Congress about passing a law to change the rule. But
I don't think honestly that a rule would survive just because of congressional intent. You can't you have to go through a rulemaking anyway when you're doing something like this. But even if you go through the rulemaking, you can't just basically say, well, we went through a rulemaking, so therefore we can completely ignore Congress. In this case, Congress has pretty expressly, they have revisited adjustment of status multiple times.
Yeah.
Since the, USCIS is in this bit of a time warp, thinking that they're looking at what Congress intended when the law was originally created and ignoring the fact that Congress came back and revisited adjustment of status multiple times over the last 50 years.
Yeah,
to make it broader and easier. And so they're going to lose, and they're making this silly argument on Patel v. Garland, which is says basically that the Supreme Court also gave USCIS a lot more discretion in terms of individual fact-based cases and not overruling what they were saying in those cases. But that doesn't say anything about changing the substantive standard that they're using, and doesn't authorize a presumption against adjustment of status. All it does is say for particular facts in a particular case, they're not going to allow judges to go in and basically overrule an agency's determination in an individual case. But Patel doesn't protect them here in the litigation standpoint. And there already are conversations I can tell people that are happening on litigation. Whether there's multiple suits or like what we saw with the Purdue University case from the first administration, where there were multiple lawyers that basically pooled their efforts for one big, massive case. And I can see that probably the goal is going to be to move very quickly. My guess is something will be filed within the next 7 days, seeking a temporary restraining order. That is going to probably be an effort of a lot of different groups of lawyers that will get together on that, as has been the case in the past when there's been something like this, in a similar way to what was happening with the H-1B tax from last year, where that ended up in the courts. But on the case that you and I are working on with Impact, there's like at least 25 lawyers that are working on that case with different groups. So I have a feeling it's probably going to be something like that. We had a couple of questions, and I'll push a couple of them out. Some of them are not really about what we're talking about today. So There was a question about about Iranians who don't have embassies, and if they have to consular process. So why don't you talk about sort of like what happens to Iranians when they're in that situation?
And it's not just, and so there are two questions here, actually. One is about what happens to people where there's no U.S. embassy in their home country. And actually, for those folks, the U.S. State Department, for most of those cases, there are designated alternate posts for people to process at for a whole host of countries where either it's not safe or the U.S. just doesn't have a diplomatic.
But that might be an extraordinary circumstance.
It could be an extra. Now, putting aside the fact that Iranians in particular and other folks on the travel ban list are subject to the benefits pause right now. And so nothing's going to happen on those cases while the benefits pause is in effect. But one of the things that concerns me is less for the 39 countries, because we already know what's going on with them. And to me, that seems clear that right now those folks are barred from getting immigrant visas no matter where they go. And that USCIS isn't adjudicating their pending adjustment. So putting the 39 country folks aside for just a second, because they have their own issues that have been going on now for the better part of 5-6 months that, we're all pretty familiar with. But, there's this immigrant visa pause that applies to people from a broader list of 75 countries where the State Department said, hey, we think people from these 75 countries are universally a public charge threat, meaning that we think that they're all poor and they're going to end up on welfare in the United States. And so as a matter of policy, we're going to pause the issuance of green cards to people in those countries who might seek to come to the United States. But in the meantime, those people from the 75 countries, as long as they're not also on the 39 country list and they're not a perfect match, they've been able to get green cards from inside the United States. Now, with this new policy, if USCIS is going to look at being on the list of 75 as a negative discretionary factor, which they have not said and we do not know, but if they do look at that, if folks on that who are from some of the 75 countries, if their adjustments are denied and they are put into a position to consular process, that walks them right into the immigrant visa pause. And there are ways to ask for an exemption to that if you're a high net worth individual and can really show that you're not likely to become a public charge. I know there have been some limited exceptions provided to that immigrant visa pause, but that's a whole other ball of wax once you get into that side of things. And so this policy, depending on how USCIS applies it, can have very significant consequences from people who are from countries that are on some sort of ban or pause list. And for right now, that's not an accident. And so the government isn't necessarily going to rush out to say, oh, yeah, for you, if you're on that 75 country list, we're going to work extra hard to approve your adjustment so that we don't push you into that other bucket. That may be something that USCIS is thinking about behind the scenes. I have not, as I said, I have not seen them say that. I'm just thinking about where their brains might be on these things. So that is a very, very serious consideration.
All right. This is an interesting question about asylum adjustment, asylum adjustment, I think, happens under INA 209.
Yeah, it's not
under 245. So I don't think that's covered in this memo. And obviously they can't consular process in their own country. That's kind of the whole point of asylum.
Yeah.
So Ariel, I think that's an important point you're making, is that we're not talking about asylees here. We're talking about most categories for family and employment and others that are mentioned specifically in Section 245I. But I don't think that's one of them.
Yeah. And actually, I was somewhere today, somebody was talking about in the memo, they specifically cite to certain types of adjustment applications that are not discretionary. And I think asylum-based cases were one of those. And I forget what the other ones were, but there were like 3 categories that are not in 245 and they're not part of that discretionary. So I think those are probably okay. Somebody asked me online earlier today if this applies to adjustments in removal proceedings before an immigration judge. And at first I was like, I don't know. I don't know, that's outside my domain, and I don't know how EOIR considers USCIS adjustment policy when they're looking at adjustments in proceedings. But I don't see what would keep an immigration judge from viewing this as a discretionary decision.
Yeah. Somebody asked about an adjustment under as part of EB-5. That's covered by this. So it does impact EB-5. It impacts all the employment categories, all the family categories, and the DV and some of the others.
Now, it only applies to I-485s. I've gotten questions today about I-140s. This does not relate to I-140s. This does not relate to I-130s. This does not relate to applications for work cards or travel documents that you might have filed along with your I-485. This policy that was announced today, this memo that we are discussing today, only relates to the adjustment of status itself. So if you are not about to file one, if you're long backlogged, and you can't file an adjustment, this is not something that I would lose sleep over right now, because by the time you might file an adjustment of status application, this hopefully will be a distant memory. If you have a pending adjustment application, there's nothing in particular you need to do right now, other than maybe, be on the lookout for requests for evidence. But, for really for people who are about to file, those are the folks right at, kind of that are this most effects in this moment, because there's on your own, you have your own discretionary decision to make with your lawyer about exactly how you want to file this. If you want to file it right now, if you want to wait a couple of weeks, if you want, there's no right or wrong answer on that. I don't know that waiting makes sense. Nobody.
If you file it now, no one's going to be looking at this application for
a few months.
6-8 months, however long it takes before the examiners actually even open the file and start working on it.
Yeah.
And at that point, I think the litigation will, it'll be pretty clear whether, if this rule lives or dies, it's going to die. It's going to be a long time before that, before an examiner is working on your case, if you're thinking about filing it soon. Now, with that said, you want to be proactive in terms of what you're putting in that application. So I don't think I would file an application right now without addressing the extraordinary circumstances.
Yes, I agree.
I would put that in there and not, if you want to wait a couple weeks and see what happens with the litigation, then maybe you don't have to spend all that time on working on that part of it. But if you are planning on filing your application pretty soon, I would start talking to your lawyer about what kind of additional evidence that you're going to put in the application and how your lawyer is going to address those issues. Yeah. And your lawyer is going to tell you it's going to take some time, because it's not just you, it's all the cases that they have in their office that they're planning on.
I want to also clarify, because a client asked me this question today, and I see a question in the chat about this as well. This memo does not say that people who have pending adjustment of status applications need to leave the United States. It does not say that. It doesn't say that one bit. And it also doesn't say that USCIS is just going to wholesale deny every pending adjustment or refuse to accept applications. If you have a pending adjustment of status application and you have status that allows you to stay in the United States, stay. There is nothing that says you have to leave. The way this memo, I understand the way this memo sounds, it's like, oh, well, nobody can adjust anymore. Everybody has to leave the United States if they want to apply for a green card. But that is not actually what it says. And so you do not, there's nothing that says that people with pending adjustments have to leave the United States. And so I just want to clarify that, because I saw it in the questions, but I also got that question from.
I would put a asterisk there, which is, you don't have to leave because I agree 100% what you said. If you don't have an underlying non-immigrant status, however, you are not, this is not new. We've been telling people for long time, years, to keep an underlying, probably my whole career, to keep an underlying non-immigrant status if you can. Don't rely on your EAD card if you, and let your H-1B status lapse. And the reason for that is, if they deny your adjustment all of a sudden, and you don't have an underlying non-immigrant status, you could, and this administration is going to issue up a notice to appear, and you're going to be in removal proceedings. And it's a complete mess to try and get out of that and then fix it all through consular processing, because once you are in removal proceedings, you can't just like leave the U.S. And say, okay, we're going to consular process now. Then you have to actually get out of removal proceedings, and that's a process, and that could take a long time. So keep the, I had a doctor that was talking to me today about, and they have an EAD, and they have an employer that wants them to just rely on their EAD and doesn't want to bother with an H-1B. And I was trying to convince them, it's like, I don't care how great a job offer it is at that employer, it's putting you at risk. It's putting the employer at risk of losing you as well. And they shouldn't be they shouldn't be so stingy on the cost when they had, in fact, this person, there was no cap issues. So they were perfectly capable of filing an H-1B if they wanted to. But I think a lot of people are going to have to put their foot down and insist on a non-immigrant visa being filed for them, and not just the employer getting to free ride on an EAD card.
I agree. And I think the risk is actually doubled, because now if USCIS is going to look at your immigration history as part of the discretion, right? So you filed your adjustment when you had a valid non-immigrant status, you were on an H or an O or an L, or whatever it was, and you had a valid non-immigrant status when you filed adjustment. In the past, that's all that mattered. After you filed the adjustment, if your status lapsed, that didn't really factor in, because the adjustment puts you in what's called a period of stay authorized by the Attorney General. You are now allowed to legally stay in the U.S. based on that adjustment. This administration has taken a really dim view of that legal fact. And under this discretionary policy, they say that they are going to look at your immigration status and history as a discretionary factor. And one of my concerns is that for people who have let their status lapse while waiting on a pending adjustment, that those folks could be extra vulnerable to a negative exercise of discretion, because USCIS is going to see that lapse of status as relevant. In the past, that wasn't really the case. And we've seen this come up over the course of the last year, where people, were in a valid status, maybe a B, maybe an F, maybe a whatever it was, that status lapsed. And then when they go for an immigration interview, the immigration service either takes them into custody or denies their application, because they see them as a visa overstay, even though they really weren't. So I would definitely say, for folks who don't have who have not maintained an underlying status, that's a particular vulnerability here.
Yeah. Okay. So I mean, there are lots of questions here about how is this going to affect my DV lottery adjustment? How is it going to affect my marriage-based adjustment to a U.S. citizen? And I think all of you can still, nothing has changed about whether you're eligible to file for adjustment of status or not. What they're talking about here is how they are, whether they have more discretion to deny and force you to consular process after you've already filed. So if you're eligible to file an adjustment application, this memo doesn't change anything in that regard.
Mm-hmm.
What it changes is what evidence that you should provide. At least I have a feeling we're going to see something similar to what happened with the proclamation on H-1Bs last September, where they issued something super broad like this. It's super broad. Well, what they ended up doing was, after they got, a weekend of screaming from corporate executives who were like, why, I have people that are stuck all over the world right now trying to figure out if they can get back in. Then they, speaking of gaslighting, they said, y'all were just like overreading it. We never meant to do that, even though they totally meant to do that. And they narrowed who it applied to. And in that case, they said it was only applying to people after that had filed H-1Bs after the proclamation went into effect. I am guessing that something similar is going to happen here, where they're going to say that pending applications are not going to be affected. But that's not what this says right now. And you should assume, until we hear otherwise, that that this affects you. What you should do, if you've already filed your application, is wait. Mm-hmm. And if they are applying it to your application, they're going to issue a request for additional evidence and give you an opportunity, or they're going to give you an interview and they're going to ask you about this at the interview. My guess is that before you come to the interview, they're going to send you a memo that says bring documentation about these factors with you to the interview, and the officer will make a decision at the interview about whether you meet the extraordinary standards or not.
Yeah.
But I have a feeling that they're just going to apply this on a go forward basis if it ever gets to happen, because by the time they issue instructions to officers, hopefully there'll be a TRO, and this will be a die quick death.
And one of the frustrating things about this policy, I mean, there's so many things, right? But one of the we have been seeing green cards getting approved really efficiently this fiscal year. Almost every case that I filed in October or November that hasn't retrogressed or anything, they've been approved. I have clients from India who had like 2013 priority dates, who filed in 2020, retrogression happened. They're finally current again, and they're getting approved as recently as Tuesday of this week. So, or Wednesday. So, USCIS has been approving adjustments at a really good clip this fiscal year. And so I'm hoping that this doesn't slow things down, because so many of my clients have benefited from their good work over the last, since this fiscal year started. It's really been remarkable, to be honest. And so I'm a little bit concerned about how this will affect that flow that they seem to have found. And, as some of my friends online have pointed out today, this could be a nothing burger. This could just be designed to scare everybody and freak us out on the eve of a holiday weekend and try to ruin our weekends, which I have sworn it will not ruin mine. I'm going to have a really nice long weekend.
Too. Everybody watching should also.
And so, I think the timing of this was not accidental. The anxiety provoking nature of this was not accidental. I don't think that this was done just for show. I do think that the Immigration Service means to implement this in some way, shape, or form. But as we've said a few times, part of this is going to be a wait and see approach to see exactly what happens. And for people with pending cases, we're just not going to know until we see action on those cases. I would not reschedule interviews that are coming up. If it were my client, I would say still go to the interview. You may want to bring some evidence with you regarding your good moral character and things like that in case it's requested, but I wouldn't put those off. I would still go. I think that the officers may not be fully apprised of how this is supposed to work, and you might benefit from the quick nature of when your interview is coming up. So I would still plan on pursuing your cases the same way you would before. And so, and some of us have been talking today about, as I just mentioned, part of the psychological part of this policy is to scare people and create anxiety. So if you decide I'm not going to file, if you decide I want to put my interview off, if you decide I'm going to withdraw my case, then that feeds into exactly what they're trying to do, like a bully. When the bully comes at you and tries to get your milk money from you, and you don't fight back, they win, right? Because they've gotten your milk money and they've made you upset. But when you fight back and you stand your ground and you assert your rights, then the bully kind of goes away because they don't get out of you what they want. And so I think
that's why litigation is. That's why you have to sue on everything. You let nothing go. There have been, Lisa, some questions from people that are in non-immigrant categories that are not dual intent. And so for the students and for the Ps and for some of these categories that are not your dual intent categories, what do you have to tell them?
Yeah, it's a harder case. But what I would say is if you haven't filed an adjustment yet and you're in one of those categories, first of all, you need to have a lawyer look at your case individually. And we are not in a position to do that in this non-confidential setting. But I would say that you probably want to submit your adjustment with proof of your positive discretionary factors, all of the things. What are you studying, right? If you're studying in some field that is really important to the national interest of the United States, if you're making important contributions, if you've got a great job lined up, if you're, I think I saw somebody mention a P1, depending on what team the person's on and what sport it is, I would try to supplement that adjustment with information and really good, how are you involved in your community? Do you mow your neighbor's lawn every Sunday? Would they be willing to write a letter saying that you're mowing their lawn every Sunday and what a nice boy you are, or girl? all of these kinds of things. If you haven't filed yet, I would think about filing with that, because the likelihood is that your status is going to lapse. You're not necessarily going to be able to extend it while your adjustment is pending, and you want to have something in the record. Now, if your adjustment's already pending, as we said, just wait. I have seen P1s get extended during the pending of adjustment, but I feel like that's a little bit hit or miss. You can certainly extend O's, H's, and L's, E's, but as
you are in status while you filed for an extension, so at least you have the benefit of that, even if it's ultimately going to get denied. Hopefully, the adjustment will happen before it even gets to that point.
Yeah. So, and I think that those cases are a little trickier, but I would, if you have a pending case already, of course, you're going to need to just wait out the immigration service. I saw a question in here also about retrogression for people who might be from India. They've got a long pending adjustment. Nothing's going to happen, right? Like nothing, retrogression, your case will still continue to be pending. Maybe you get an RFE at some point along the way, but like literally nothing is going to happen on your retrogress case.
It'll probably be the Gavin Newsom administration or whoever's the next president, whoever the next president is. It'll probably
this policy has nothing to do with the visa bulletin, and it has nothing to do with the visa bans. The way it is written, it applies to everybody equally. There are no special carve outs for people who are on the 39 country list. It's not going to affect those people extra. It kind of does in its application potentially, but there's nothing in the memo, and anybody can pull up the memo. It's on the USCIS website, and you can see for yourself. It doesn't.
There is potentially a tie-in, because if in one of these 39 country suits, if it's order, if there's an adjudication order, preliminary injunction, and then they tell them to go back and actually work that case, and it's an adjustment case, if depending on the timing of the litigation on this issue, it could be a problem if they all of a sudden they are going to adjudicate the adjustment and they're applying this now much more difficult standard. The timing matters as far as when the verdict, when the injunction might be issued in that case, or it might affect like the doctors, for example, although I think the doctors have very good extraordinary standards.
Yeah.
But they've just said all these doctors now, they're going to move forward and work on their cases at some point, hopefully soon. It's starting in drips and drabs. But those, they just got out of that one, they got out of the one fire, and now they're in another one with where they might work on their adjustment application and then apply this new barrier. And there was somebody who was saying, it's like, are they sort of reacting to a couple of preliminary injunction denials that have come recently for the dozens of cases on the 39 countries? It's like, no, that is not this memo, I can promise you, has been sitting in Stephen Miller's desk probably for months and months, and they have been planning it out, and they're not paying attention to what's happening in one little court in one jurisdiction for about 100 plaintiffs or not. So I wouldn't try and game it out to that level. That's not what's going on. All right, Elisa, I don't think I have anything left to say, and I think we've covered it. I know that we just sent out to all our clients our memo today. We'll probably be pushing it out over the next couple of days to a broader audience. The memo, that excellent client memo that you wrote today. So but you hit most of those issues here. If you are late to this, you can watch it on these channels and just go back. So people are asking questions now that were answered earlier. No, asylum adjustments are not covered by this. And there were other questions that were here. So hopefully, if you came late, go and watch some, especially the earlier part where Elisa was going and doing the deep dive and explaining what the memo actually does, because I think it's important to know that and read it and read the memo to yourselves and get familiar with it. The best clients are the clients that actually are educated about immigration law and know when their immigration lawyer is giving them instructions why that's happening, and that they are diligent in following those instructions. So I am going to end. And Elisa, do you have anything final you want to say?
No, just what it says in my headline is kind of how I felt all day today. So I hope everybody has a relaxing, I hope you get to take advantage of the long weekend ahead of us. Everybody has a relaxing weekend. I know this stuff is really nutty and it can really mess with you, but also taking time for yourself is really important. So I hope everybody gets some downtime. I know I will. And have a good one, everybody.
All right. Take it easy, everyone. We're going to end here.